Hello, my name is Benjamin Hart. I'm an American attorney and the Managing Director of Integrity Legal here in Bangkok, Thailand. As the title of this video suggests, we're discussing I-601 waivers. For those who are unaware, if one is found to be legally inadmissible to the United States, meaning that a person has on their record either a criminal record or even if not convicted or arrested, if they have a history of illicit activity that meets the definition of a grounds of inadmissibility to the United States. Good examples of these that we've seen oftentimes involve drug usage, even though one hasn't been convicted, or things like prostitution, crimes involving moral turpitude, even where someone has not been cited, arrested, convicted, anything. If they have participated in certain activities, they may be deemed inadmissible to the United States. Now, there may be a remedy for a finding of inadmissibility for a visa denial. In this case, we're specifically talking about the K-1 Fiancée visa. And generally speaking, that remedy is what's called an I-601 waiver, or a waiver of inadmissibility using the I-601 form. Some people get kind of pedantic about that, but long story short, that's what you're dealing with. You're dealing with a waiver of inadmissibility. Possible to get one, depending on circumstances. Can be difficult. Waiver cases are substantial. Oftentimes they look like more than one phone book worth of documentation. So the thing to take away from this video is, yes, it's certainly possible to get an I-601 waiver. That's all going to be entirely fact specific. Some people ask me, are K-1s treated differently for purposes of a waiver, i.e., because we're not married, are we treated differently than if we were married? And legally speaking, and this is something I got to give credit to a certain extent, even though it's something they're legally obligated to do, the Department of Homeland Security does not treat K-1 fiancés any differently really than, in fact, legally they're not allowed to, any differently than marriage visas. In fact, legally, during the adjudication of an I-601 waiver application, the K-1 fiancé needs to be treated, again, legally speaking, as if they're already a spouse. So that issue for folks really isn't a major issue. I do get that question from time to time. But the thing to take away from this video is, yes, there may be a remedy for a denial of a K-1 visa, depending on the circumstances. That remedy is very likely an I-601 waiver. Those who are looking to get an I-601 waiver, is highly advisable. Contact a legal professional, gain some insight and guidance into how best to proceed.